Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is Head in the Clouds, Balancing Convenience with Reasonable Care. Speaking today will be Jared Correa from LOMAP. Jared is the Assistant Director and Senior Law Practice Advisor for LOMAP, the Law Office Management Assistance Program in Massachusetts. Before joining LOMAP, Jared managed CLE Publications and the Casemaker Research Engine for the Massachusetts Bar Association. He has been a practicing lawyer in small firms where he mostly focused on personal injury, real estate, and disability law. Jared is a regular contributor to local and national legal publications, including Attorney at Work, where you can find his monthly column entitled Managing. Jared is the author of the American Bar Association publication Twitter in 1 Hour for Lawyers. He's the co-host of the podcast The Legal Toolkit on Legal Talk Network and is featured on a quarterly podcast at Solo Practice University. Jared also presented at ABA Tech Show 2013 on remote access and social media marketing. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay updated on legal technology news through our blog, www.lawtechnologytoday.org. Thank you all for joining us, and we'll now begin the webinar.
Thanks, Chelsea. And thanks, everybody, for listening in today. I appreciate it. So today, jumping into the webinar, getting to the substantive matter, I'm going to talk today about using reasonable care, as well as trying to find the convenience that is built into a lot of the cloud technology systems available to lawyers these days. And as Chelsea said, I'll take questions at the end. So I'll go for about half an hour, and then we'll do whatever Q&A you want, and hopefully we get some good, interesting questions that I can provide robust answers to. So let's start in one of the places that lawyers love to be, talking about risk. Lawyers, as you may know, have a low risk tolerance. And when it comes to using the internet to store data, there is certainly some risk involved. There's no surety, no guarantee that information you store online will be totally safe at all times, will be completely immune to hackers. In fact, if you look at the statistics, most small businesses will have an incident of data breach at some point, and as time goes on, probably more likely at points during the history of their operations. Now, the part of that is less discouraging is that many of those data breaches are occasioned by user error. So while there are some risks when you're allocating your data to the web, it's not necessarily any more risk than you would take setting up a traditional solo or small firm law practice. Now, I'm a consultant and I go into solo and small firm law practices all the time. And I will tell you that in most practices, the majority of practices that I go into, lawyers utilizing cloud solutions and storing their data that way are probably storing that data in a more secure way than they would in their own practices. I can't tell you how many law firms I go to where lawyers have files left open on desks, doors unlocked, file cabinets unlocked, people who are not personnel from the law firm wandering around the office, stuff left on fax machines, stuff left on copiers, stuff left on printers. If you're allocating your data to the web, there are certain security protocols that can be used if you're using the right software. So while you would never be able to eliminate the risk of using a cloud-based system and putting your data out there or in there as an attorney, you may be surprised to learn that the risk may be higher if you continue to run a law practice in the way that a law practice has traditionally been run, including using paper-based documentation. So going paperless, adopting a cloud system has certain advantages. And that's part of the reward we're talking about here. Although this young gentleman has a really old school looking computer, that thing looks like it weighs about 900 pounds, and if I was going on a tropical vacation, that is not the computer I would take with me. But that being said, if you have cloud technology that you're using in your practice, what that means is that you can access your data from anywhere. So you don't necessarily have to be wedded to an office any longer. You could work from the beach if you wanted to. You could work from home. You could work on vacation. A lot of the attorneys I know who use cloud technology, they'll take 6 weeks off in the summer, though they won't really be off. They'll be in another location. I live in New England, so we can travel from state to state pretty easily. I was talking to an attorney the other day who's going to take 6 weeks off in the summer, go up to Vermont, and service his clients as if he were in Boston, because all of his data is in the cloud, and he has access to it wherever he has an internet connection. Now, before leaving the topic of risk entirely, if you're going to use a cloud-based system, you need to have the internet to access it, and you want to always have a secure internet connection. So while we talked about being able to work on a beach, being able to work at home, some places where you don't necessarily want to work is Starbucks, and you don't necessarily want to be using Starbucks internal wireless that's free to everybody. You want to have a secure wireless system, and then you can effectively work anywhere because you're mitigating the risk at that point. You're attempting to thwart any hackers or folks who want to gain your information to do negative things with it. And we'll talk about some techniques you can use to protect yourself further. But with the cloud, you can be flexible. And that flexibility not only extends to location, it also means that you can ramp up or down your business more easily than you otherwise would. If you're a small firm and you want to add an employee, a secretary, paralegal, associate attorney, it's very easy to say to your provider, I need another license, or another person is going to be working for my firm, so they need a login. That's super easy to do if all they're doing is accessing cloud-based software. And this is a sea change from the way it used to be in running a law practice. If you were adding an employee previously, well, you got to find them a chair to sit in, of course. You've got to find them space in your office. You've got to buy them a device, like a laptop, maybe even buy them a smartphone. Maybe you configure their smartphone so they can use it with those systems that you had in place. It's a far more intense undertaking, far more expensive undertaking than just ticking up a new license and adding the cost of that to your bottom line. So there's a lot of advantages in mobility and flexibility if you're willing to move to a cloud-based option. The other thing that's advantageous about this is that it used to be that if you wanted to gain access to your information outside the office, you used to have to use a remote protocol of some kind. So you'd have all these local applications that were built into your computer, and you would access that using a sort of go-between, a remote access protocol. Now the problem with that is that you're transferring information back and forth, so that information is exposed when it's being transferred. It could degrade the information that you have in place, especially if it's being transferred so often back and forth. And it's just not an effective way to practice when there are other options available, which is more direct access to online tools, which is what the cloud represents. I think most people sort of intuitively know this. So the problem that many lawyers have is they recognize the business advantage to using a cloud-based system, but by the same token, they're worried about the risk. So they sort of sit between these two options, not knowing which way to go. Do they value the risk more highly? Do they value the reward more highly? And what do they choose based on that? Well, the good thing about this is that there are ways to compromise on this. So the tactic that I see many firms using is realizing that there are advantages to cloud-based software, but that such software is not perfect. And there are ways to mitigate your risk. And the ways that you mitigate your risk is that you add security to the existing security that the cloud-based systems offer. And that's a pretty straightforward description. And the question that I often get from people when I tell them that is, yeah, that sounds reasonable, but how do I do it? We're going to get to that. Trust me. Stay on the line. But before we get to that, yeah, stay on the line because you never know when you're going to get to see my inbox again. But before we get to that, let's talk about some of the rules that are in place. So this is not a barren playing field necessarily. Now, there's not as much guidance or as much directed guidance as there could be on this topic. But there are some rules in play when we're talking about using technology, especially cloud-based technology, as a lawyer. So At the most basic level, the ABA model rules of professional conduct have recently been updated, and a comment 8 has been added to Rule 1.1. This says that lawyers have to keep abreast of technology within the practice to be competent. So part of your duty as a lawyer with respect to competency is understanding how to use technology in your practice. So that's an affirmative obligation that was added that had not existed previously. Now, this is not the case in every state. As you know, of course, the ABA model rules are just that, model rules. They're illustrative. Not every state has adopted this comment, but I think about 20 have at this point. But it makes sense. I mean, you see cases where lawyers don't have email addresses or are not checking their email. Well, in a modern practice, you can't do that. So you have to be aware of technology. So no longer is there this option to stick your head in the sand and have your secretary print out all your emails for you and manage your practice that way. You have to be involved in decisions about technology and using technology in an effective way. Add to that the fact that most states have now come, well, not most, I shouldn't say most, but there's a national consensus that's gathering. Many states have produced ethics opinions on cloud-based technology used by lawyers. So if you look to the Legal Technology Resource Center, LTRC, through the ABA, they have a list of all the cloud ethics opinions for all the states that have produced such ethics opinions. There are about 20 at this point. And if you look at what those opinions say, they say if you're going to use cloud technology as a lawyer, that use has to be reasonable. And that reasonableness extends to the security of those systems. So the data also has to be kept secure. And as I said, we're going to talk about just how to do that. But there is now an affirmative in many states, obligations implied by these ethics opinions, that you need to keep your data reasonably secure in the cloud and use those systems in a reasonable way. Now, some states go a little bit further than that. Massachusetts, for example, where I'm from, says not only should you be reasonable in your use of these systems, but you should reasonably vet the systems that you're using. So check them out before you sign on the dotted line. Also, you want to tell your clients about what cloud-based systems you're using. And you can drop that right into your fee agreement as a clause. Get your clients to sign off on what you're using. Make sure that you get their informed consent before you're using a specific technology product. So those rules are in play as well, or those ethics opinions are in play in many states as well. So if your state has an ethics opinion, I'd encourage you to read it. But I would also encourage you not to necessarily just follow the letter of the ethics opinion if you think you should or need to do more. The problem with the rules, many of the rules, including some of the state laws, which we'll address in a second, is that they were written by lawyers. And lawyers are not particularly tech savvy. So in many cases, these are basic best practices, which you can add to if you need to. And for folks attending today, you'll get a copy of this PowerPoint, and we've added some notes on that PowerPoint with links to some of the things I'm talking about. So if you're sitting there saying, okay, 20 states have ethics opinions, where do I find information about that? Well, we've got that listed for you in the notes on the PowerPoint. The other thing you need to be thinking about is state laws. And at this point, I think 48 states in the District of Columbia have data privacy or data protection laws of some kind. And this relates to the type of data you keep as a lawyer. If that data is online, then you have some more obligations to secure it in a certain way. So many of those states identify the term of art as PDI. I'm having a brain cramp. I forget what that stands for, but it's basically private data, and they categorize that in a certain way. Oftentimes, you're looking at Social Security numbers, financial account numbers, state-issued identification numbers like a driver's license. If you're storing that type of particularly sensitive data, you have to secure it in a certain way. Some states will also say that you need to create a data management policy surrounding those specific types of data. And those are obligations that you have related to just those types of data on a state level. So some practice areas as well, in addition to keeping that data that's implicated by the state laws, also have a specific practice type that forces them to look at other rules in place about managing data. The most obvious example is attorneys who keep medical records, for example, or who practice in the health law field. Well, they're obligated to look at HIPAA rules as well, and those rules may apply to those firms also. And so I picked the number 4 here for a reason. If you're looking at some of the obligations that attorneys have or could have, you've got the ABA model rules, you've got the local rules, you've got state laws, and you've got specialty laws. So this is a sea change from what it was to manage a law firm even a decade ago. You have more data that you're keeping than ever before, and you have more responsibilities related to that data that you need to keep than ever before. So it's an onerous thing for solo and small firm attorneys to do, to be able to manage this information effectively and keep it secure. And even beyond the generic rule about staying on top of technology in your practice, if you look to the way ethics rules are being updated now, many of those changes on the local level reflect technology. So in Massachusetts, for example, Rule 1.6 for confidentiality of data, the language looks very similar to the state rules on data security, about how you have to secure your data for clients. So we're coming towards something like a national standard or a national consensus, or at least close to it at the baseline level of what you have to do to secure your data effectively as a business person, as even a small business person. So let's talk about some security features that you may see in cloud-based systems that you use. So the first thing I tell you, and again, this is required in some states, but the first thing I would tell you is that with respect to cloud-based tools that you would use, you want to be able to vet that software in a particularly effective way. And so you want to know what questions to ask before you sign up with a service. Some of those will relate to basic features we talk about here. Some of those will relate to technical ways in which those companies maintain data. And for many companies, they also have security audits that they run, which may be made available to the public. So you can look into those as well and get an idea of how company X maintains its data securely versus company Y. And at this point, I should stop and say that in addition to those specific ethics opinions about cloud-based tools that attorneys could use, there are many states that have not issued those opinions that have analogous opinions. So, for example, what I'm talking about is with respect to use of accountants, for example. It has traditionally been held that attorneys can use accountants and that accountants can view their law firm data, and that that is not a breach of attorney-client privilege because of the relationship that those accountants have to attorneys and because they're vendors performing a particular job. There are some ABA opinions on that as well. And I think if you don't have rules in your particular state, you can drive an analogy to the way attorneys have traditionally worked with consultants to the way that attorneys are now working with cloud vendors who have access to a lot of the same data that accountants would have access to. But before we get too far afield, let's talk about specific questions you might want to ask your cloud provider. That little symbol you see on this slide is HTTPS. The S stands for secure. So if you see that in your browser, what that means is that that page of that site you're on at that time is encrypted. Now, many service providers will have encrypted pages everywhere you go. Some might not, so you want to ask about that. In order to secure your data better, you want to make sure that the provider you're using utilizes HTTPS across the sites that you would have access to. Another important piece of using cloud-based technology is keeping access under control. So at a very basic level, you want to make sure that people who are using your system have the rights to use the system, so you want to be inviting the right people in. You want to be able to assure that people are using strong passwords to access the data, so you want to encourage that. Believe it or not, even today, there are many people use password for a password, 123, 1234556 if they want to get fancy. But if you look at the list of the top 25 passwords that people use, 22, 23 of them are eminently breakable. So you want to talk to staff people, and we'll talk about this in a little bit too, about creating strong passwords and how to do that, because there are some techniques that can be used and techniques that make them memorable, because if you don't have a memorable password, the thing that happens is people start to write those down on sticky notes and leave those sticky notes all over the office, and that's not what you want. So password is one aspect of this. Another aspect of this is the second factor of authentication. And what I mean by that is if somebody's going to be accessing a site like this, like a cloud-based tool that a lawyer or a law firm could use, you want to make sure that there is a second factor of authentication available. And what that essentially means is it's not just a password. You need another item to pair with that to be able to access the system. And the traditional way that folks have done this is you get a text at your phone, and it's a certain code that you also have to input. So the way this works is you add your password, you'll get a text at your phone, it'll ask you to input the information in the text, and then you can have access to the system. The theory behind this is that while a hacker could potentially access your password, it's unlikely that they would also have your phone. So that level of security is added as well. But of course you have to make sure that the system you're using offers a second factor of authentication. So those are two basic questions you can ask right off the top. Is there a second factor of authentication for access? And is there encryption everywhere that is being used? Now the other part of this permissions architecture is how that's going to work within the system. So if you're using a cloud-based system and you have a paralegal and a couple of partners and 3 associates, not everybody's going to have access to the same matters. Some people are going to be screened from matters. So you want to make sure that there's a permission architecture involved in the system so that you can close people off from some matters and allow others access to matters as well. And that can be very matter-centric as well. You could add people to matters or take people off of specific matters, but you want to have the opportunity to do that. Now, when you're using a cloud-based system, essentially what you're doing is you're renting space on somebody else's server, so you don't have to have a physical server of your own. So what you need to be thinking about is the security of those server farms where your data is being stored. How secure are those? Is there geographic redundancy? If California falls into the ocean one day, is there another server on the East Coast where you could access your information? How are those systems backed up? These are some of the questions you're going to want to ask of a cloud provider. Now, if you're looking for a list of questions that you could run down when talking with one of these vendors, I think there's 2 good places to go to generate those questions. In 2011, North Carolina put out an ethics opinion which was proposed, ethics opinion 11 I believe it was, which had 14 questions you could ask of a cloud vendor as a lawyer. Now that was never a formal opinion. It was revised and some of the questions were taken out prior to publication, but I like the original version better. So that's one place to be to get some questions. The second place is there's a Legal Cloud Computing Association, and they've just released a number of standards for cloud providers in the legal field. And you can read through that document, which is very easy to read through. I think it's 3 pages, and you can get some ammo with respect to questions that you should be asking cloud vendors, because that document does get into the weeds about security. But you definitely want to vet the cloud vendors that you're thinking about using as a lawyer. Now, in addition to that, you can add some security features of your own. And we sort of talked about one already. Very easy to set up a second factor of authentication in addition to the password that you'd use if the system allows you to do that. Another technique that attorneys are using to sort of increase security is what's called pre-encryption. So whenever you're using a system like this, the good systems are going to take your data and then encrypt it, but they're going to be the ones using the encryption password. So what you can do is encrypt a document before you upload it to a cloud server. And this is what lawyers are worried about when they read service level agreements and see that basically a lot of these vendors can share information with whomever they want, whenever they want, on slight provocation. Now, That rarely happens, if ever, and you've seen how hard Apple has been fighting the federal government recently. But if you want to secure your data at a higher level, you can add your own encryption password, which your vendor would then not be able to break because they would not have access to that. You would. So 2 quick tips about increasing your security. Second factor of authentication and pre-encryption. And if you don't want to do this manually, there are systems that would mask, essentially, these documents before they go up to another system. So there are pass-throughs available where you could use one cloud program to put an encryption code on a document before you send it up to another cloud program, if you want to do that. So I do want to take like the last 5 minutes here to talk a little bit about talking to staff and talking to clients, especially about the cloud. And we've talked a little bit about what it means to talk to your staff about using the cloud. I'm a believer that if you're going to use technology in the law practice, you need to get buy-in from your staff. If you don't have buy-in from the staff, you're not going to be as efficient because they're not going to be using it effectively. They're going to rebel against the systems that you're using. If there's a secretary that's been using Microsoft Outlook for a long time and you want to switch to Google Apps, then that's going to be a problem unless you get them to buy in on it. So I think you want to involve people in the decision making. You want people to be able to vet products with you so they can have a better idea about the technology options available to them. And then when you get staff who are using systems, you want to educate them on how do you create strong passwords. Why do you need to use a second factor of authentication? What documents are appropriate to pre-encrypt and what documents are not. If you've got a law office where there's a bring your own device policy and people are using their own smartphones, well, you want to have an IT person who can set those smartphones up in a way that they're secure. You may want to establish remote wipe protocols. So if a smartphone or a device is lost, any data on it can be wiped. You want to have these systems in place ahead of time. But you want to make your staff aware of what you're doing so that they can buy into it. Because I think most staff people understand that it's important to protect confidentiality within the law firm arena. They just don't necessarily know how the firm wants to do it because the firm doesn't communicate with them about that. Next thing I want to talk about briefly in the last couple minutes here is talking to clients about the cloud. And I think this is really important. And most attorneys don't do this. As I said, some of the state ethics opinions that are out there suggest that lawyers relay to their clients what cloud technology they use, what technology they use generally, in fact, before they start using it. And I think that's good policy. It's better to get the informed consent of your clients than to inform them later that you were using a cloud-based system that they were not aware of. It's better to get all that stuff out of the way early, just as it's better to get the money conversation out of the way early as well. So if you have a good idea of what technology systems you're using in your practice, including cloud-based technology, it's easy to develop a clause in your fee agreement that informs your client what you're using in a very specific way and then allows them to sign off on that. If you're doing, as you should be doing as a good lawyer, explaining your fee agreement and the different clauses to your client before they sign it, you can have the technology conversation then. You can talk to them about obligations they may have to secure their data, and I talk to family lawyers about this regularly. You can't assume that if you're representing the husband, his wife doesn't have access to his email or other programs that he's using. So divorce lawyers, for example, before they start sending emails to a client, they want to find out whether or not the spouse has access to an email system that they're using. And that's a good time to have that conversation when you're talking about confidentiality generally. So not only are you going to end up educating your staff about confidentiality, you'll also be able to educate your clients. It's also a good place to talk about, yes, lawyers have certain obligations to representation, but so do clients. In addition to being honest with their attorneys, being forthright, sending information when asked, they should be working on keeping data secure as well. So have that conversation surrounding a fee agreement clause, which you write into your fee agreement, get client sign off on it, and then it's just going to be an easier conversation down the road, and their representation is going to be more efficient because the client knows what's coming up and the client knows what systems are in play. Maintaining compliance is important, and there are certain ways to do that as well. Basically, you're staying on top of the systems that you're using, changes that those systems are making, but you're also keeping your staff and your clients informed as well about how the technology changes in your practice. Many states which force you to draft a document or data management program for complying with storing data in the cloud will say that you're required to do an annual review of your systems, and I think that's good policy as well. And at this time, we're at 1:30. I hope this was useful for folks. And I will say also that this webinar was presented by Abacus Data Systems. They're a cloud vendor. They're concerned about security, the security of your data specifically. And if you want to learn more about the products they offer, including Abacus Private Cloud, which is a cloud-based data storage system, you can check those products out at abacuslaw.com.